State's ready.
We're ready. Thank you. Please bring the jury.
All right, so I'm coming back on. Law and Crime and Court TV both are having evidently the same issues. But I found another one, and it's actually a little bit of a different angle, so I guess that will be nice. Okay.
Pretty brief. This is obviously the second part of our trial, and the state only has to prove one additional element, the aggravating factor. And in your instructions, you will hear that the factor is if the murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. We submitted a copy of Evelyn's birth certificate, which will show that she was under the age of 12 at the time that this murder was committed. And it also gives Megan Boswell's birth date, which also proves that Megan was over the age of 18 at the time this was committed. You get to consider not just what was in this hearing today, but anything that you heard in the trial itself. You heard from a few witnesses today talk about Megan's childhood. You're going to get jury instructions on mitigating factors that the defense would like for you to consider. Things like how old Megan Boswell was at the time, Megan Boswell's childhood, the things that she witnessed, role models in her life, etc. But I submit to you that there are a lot of people who have hard childhoods. There are a lot of people who have babies when they're young, and those people do not kill their children. Those people do not wrap their children in blankets and foil and put them in a trash can upside down.
I thought the same thing, that there's a lot of people who have a really bad childhood and all of these different things, but they don't then turn around and kill their baby. They are in penalty phase. She was found guilty on all 17 charges.
When you look at these mitigating factors, and it looks like they have submitted 11 mitigating factors, I submit to you that lots of people have childhoods like the defendant had, but you heard from her own grandmother that her grandmother and grandfather were stability for her. And I submit to you that just because you have the childhood that you have, and of course we all, you included, have different life experiences, that does not make an excuse for what she did to Evelyn. The defense is telling you that Megan Boswell deserves life with the possibility of parole, which is essentially roughly 51 years in this state, which would mean that Megan Boswell could get out in her late 60s, I believe. I submit to you that Megan Boswell she doesn't deserve that chance. Does Evelyn get the chance when she's 69 years old to start her life again? She doesn't. Neither does Megan. We are going to ask that you continue to hold her accountable. The state has proven the aggravating factor that Evelyn was under the age of 12 years old and that the defendant was over the age of 18. We have proven that. And that is all the state has to prove. And if you believe that the state has proven that beyond a reasonable doubt, we're going to ask that you return a verdict of life without the possibility of parole.
Thank you, John. Mr. Horn.
Ladies and gentlemen, I know the last few days have been emotional for you. It's been emotional for everyone. That emotion really began 5 years ago. Not just for this case, but for our community. And it has had some dividing and rippling effects. You've been sequestered, you haven't seen those things, but we have. We've seen how divided this community is over this case. Perhaps that could last and go on for a long time. You spoke very loud today when you found Megan Boswell guilty. And I think it's time that we end all of this on the right note. You have a chance to do that. I don't, state doesn't, judge doesn't, you do. You can put the defining moment, the period of what people will remember about this case, and perhaps you as jurors, because you did find her guilty. And now you have a chance to do and show the one thing that's been missing for the last 5 years. That's grace and love. We have all, everybody in this room has failed in some way in their life. It may not have resulted in a criminal charge. It may not have resulted in going to prison. But we've done something. We've wanted compassion. We've wanted grace. We've wanted love. That's how you can end this. And that's how we can start to move on as a community. And you can show her what love looks like. Because you've heard how fractured and dysfunctional her family is. Mr. Scott told you in the trial, he didn't go through a lot of things in her life. I didn't either. But I knew my mom and dad loved me. They loved me to the end. My family now loves me to the end. I don't think she's seen what that looks like in her life. You're going to get a chance Go back there and show her. You can tell her that she's redeemable. You can end it with grace and love. General Boswell told you about those mitigating factors. You'll get them in your jury instructions. Spare her life and give her life without parole. If there's anything good can come from this, is that we can all move forward, knowing that you got the verdict that you wanted, and you ended it with the emotion of love and compassion. That's what will be remembered. I hope that's what you did. Don't be remembered for just compounding the tragedy and the tragedy and the tragedy. So easy to do that. The lasting impression that you give Evelyn, that you give Megan, that you give this community, is that love and grace can still be found with all of us. And we ask you to give her life. And let her have a chance to come out one day. That's justice as well. Justice for everybody. Thank you.
Thank you. Jim.
Thank you, Judge. Ladies and gentlemen, your job at this point is to determine whether or not the state has proven the aggravating factor that we alleged. And as General Massengill told you, that was simply related to the age of the child as well as the age of Miss Boswell. And clearly through her birth certificate, we have proven that aggravating factor. So then your job will be to weigh the mitigating factors that the defense has put on for you against that aggravating factor, which we have met our burden of proving. Mr. Horns asked you to end this case on the right note, and they would agree. You should end this case on the right note, and you should show Megan Boswell the same compassion and grace that she showed Evelyn. Evelyn wasn't shown any compassion. She wasn't shown any grace. You know, the one person that Evelyn should have been able to rely on to protect her, keep her safe, abandoned her, discarded her. She doesn't deserve your passion, your grace. State asks that you weigh the aggravating factor that we've proven in this case. The fact that Evelyn Boswell, at the time she was dumped in a trash can, wasn't even 13 months old, never had a chance. We ask that you return a verdict we've requested of life without parole.
Thank you, General. Okay, ladies and gentlemen, I've got another set of instructions I've got to read to you. In the criminal court for Sullivan County, Tennessee at Blumville, State of Tennessee versus Megan Boswell, defendant. Case S72869. Jury instructions. Fixing punishment of life imprisonment or life imprisonment without the possibility of parole. Members of the jury, you have now found the defendant guilty beyond a reasonable doubt of first-degree murder in the perpetration of first-degree murder as charged in the first count, and first-degree murder in the perpetration of a felony as charged in the second and third counts of presentment number S72869. It is now your duty to determine, within the limits prescribed by law, the penalty which shall.
It's every station is having this issue. I'm gonna check and see if Law and Crime got theirs fixed. That's crazy. I'm wondering if there's just like too many people trying to watch and it's making them crash. Alright, I found one that is still going. So I'll pull it up.
Either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. Verdict: life imprisonment or life imprisonment without possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravating circumstance proved by the state beyond a reasonable doubt and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravating circumstance so found, and you shall return your verdict upon the enclosed form attached hereto and made part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. Here list the statutory aggravating circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. I've got verdict forms for you. Okay. I have verdict forms for you, and I will read those. Verdict form, count 1. Punishment of imprisonment for life. We, the jury, unanimously determine that no statutory aggravating circumstance has been proven by the state beyond a reasonable doubt. We, the jury, therefore find that the sentence shall be imprisonment for life. Signature line, jury foreperson, signature line for each juror to sign. A date with a line. Verdict form, count 1, continued. Punishment of imprisonment for life without the possibility of parole or imprisonment for life. We, the jury, unanimously find the state has proven the following statutory aggravating circumstance or circumstances beyond a reasonable doubt. Check the box of any statutory aggravating circumstance or circumstances you find beyond a reasonable doubt. Check box. The murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. Below, check one box only. Check box. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or checkbox, we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. Signature line, jury foreperson, signature line for each juror. Date, signature, blank. And the same exact form verbatim for counts 2 and count 3. Take the case, consider all the evidence fairly and impartially. Complete one of the 2 forms for each count. And report your verdict to the court.
Go with the officers. Everyone stand, please.
All right. So, with that, the jury is going to go out and deliberate. I bet it's probably going to be just like a couple hours max. I bet they come back pretty fast. I think it's crazy that all of the people who are streaming it all got issues at the same time. So hopefully they get that fixed once the jury does come back. I really was hoping Megan would read a letter or say something before the jury left to deliberate. I just wanted to see where her mind was at with everything. And we haven't had the opportunity to see if she is remorseful. I mean, we just haven't seen anything. And since she's opted not to talk twice now, we're not going to. So I'm a little sad about that. Would have liked to see it, but at least we're moving right along and there should be a verdict on this one very soon. All right. Thank you for watching. When they come back, will be back. But since it could take many hours, I'm not going to just sit here and have us watch a blank screen. I will be doing the rose petal murder very soon. I'll probably even just create the live, and depending on what happens with this, I'll just go into that. So, all right, if you've been with me most of this, thank you so much for watching, and I will see you later.